Don't have time to sift through all that clickbait? Pfft, me neither. Here's the latest in 2A news. Trump's DOJ has made history with a recent brief filed at the Supreme Court. Right now, a case challenging Hawaii's sweeping carry ban that was passed post-Bruin is waiting for the court to decide if it's even going to get heard. To bring you up to speed, this case was filed in the summer of 2023. After a preliminary injunction was issued, the state of Hawaii appealed the decision to the Ninth Circuit. This case was combined with two others from California up at the Ninth Circuit, challenging California's similar bans on carry. So, it was a big gross mess of carry bans in front of the court. Ultimately, the three-judge panel ruled against the people challenging Hawaii's law, which required individuals to receive permission to carry on private property. Can you freaking believe that? You need permission to carry? Huh. I know some of you guys aren't going to like that one. So, to give you guys some clarity, prior to this law, a store would have had to post no guns allowed to prevent someone from carrying, at least lawfully. Now, the new law that's being challenged requires that the store posts you can carry in order to do so lawfully. And all those stores that don't have any signs posted are assumed no carry zones by virtue of the law. Where previously, those stores that didn't have any signage were assumed good to go for carry. Weirdly, this differs from the Ninth Circuit's finding on the California law, which did the same thing. The difference? California's law required some posting of notice, while the Hawaii law allowed for the posting of a notice or for the property owner to give oral or written consent. Well, according to our friends at the Ninth Circuit, that was enough of a difference to make the Hawaiian law constitutional, while the California one not. So, the plaintiffs in the Hawaii case asked the Ninth Circuit to rehear the case en banc, which was denied, bringing us to the Supreme Court. En banc means all the judges. Now, that historic move by Trump's DOJ, a brief was filed in support of the challengers to Hawaii's law. And that's never been done before. And it wasn't something on my bingo card. The feds supporting the Second Amendment? Shh. Wild. So, in the brief, the government stated the United States has a substantial interest in the preservation of the right to keep and bear arms and in the proper interpretation of the Second Amendment. The DOJ went on to say Hawaii's novel default rule defies, indeed effectively nullifies, the general right to publicly carry arms. And that is no accident. The structure and operation of Hawaii's law reveal that the law serves no legitimate purpose and instead seeks only to inhibit the exercise of the right to bear arms. Put simply, the federal government is shockingly arguing that Hawaii's law is unconstitutional. And while the Supreme Court may choose not to take this case, if the administration's actions here are indicative of how it's going to interact in Second Amendment cases, gun rights might just get some help in the courts from the feds. Welcome back to the Big 2A, the show where we bring you all the top 2A stories. I'm your host, Adam Kraut, and if you're not dreaming of GunCon, what are you doing? This year has over 40 different companies and an exciting lineup of panelists. Get your tickets for GunCon in Cleveland, Ohio on June 28th at guncon.net. GunCon! Oh, and use TGC at checkout. This just in, Adam Schiff is still
a douchebag.
In an attempt to remain relevant, Schiff has reintroduced a bill that's gone nowhere for the past 2 decades. And what is that, you might ask? An assault weapons ban. Apparently, the age-old adage of if at first you don't succeed, try again, rings true with Schiff. The assault weapons ban of 2025 is 126 pages of the same old tired approach that was previously championed by the late Dianne Feinstein. For brevity, we'll keep this at a real high level. The bill would ban the sale and possession of assault weapons and, say it with me now, high-capacity magazines. There's a list of banned firearms as well as a features ban. They're going for the high score on this one.
New high score!
What does high score mean?
Also included a massive list of firearms that are specifically excluded from the ban, and that list 96 pages long, which has exactly what you'd expect on it. Things like the Krieghoff K80, the Husqvarna side-by-side shotgun, Uberti rolling block carbines, Ruger Mini 14 without a folding or telescoping stock or pistol grip, the Remington Nylon 66 autoloader, and 17 different versions of the Winchester Model 70. It also has a grandfather provision, so if you like the assault weapon you have, you can keep it. The good news? This piece of trash is DOA, given it only has Democrats as co-sponsors, lacks the votes to make it through the House and Senate, but hey, at least
douchebag
can go back to his constituents and say he's doing something other than wasting our oxygen. But Congress isn't a complete disaster chock full of anti-gun legislation. Well, at least one part of that statement is true. They are a disaster. We have some positive 2A news. Last week, South Carolina Representative Sherry Biggs introduced the Protecting the Mailing of Firearms Act. This bill is a breath of fresh air with some large-scale implication on a rather practical problem that many people face. If any of you have sold a gun that needed to be shipped within the last couple of years, you know what I'm talking about. For those that haven't, let's make this simple. Federal law prohibits the shipment of pistols, revolvers, and other firearms capable of being concealed on a person through the Postal Service by someone like you and I. This does not apply to FFLs. Long guns can be mailed through the USPS, but almost no one does that. Shipping guns used to be accessible to most people through FedEx and UPS, but over the last few years, both carriers altered their policies pertaining to the shipment of firearms by private individuals. Put simply, you can no longer ship firearms using FedEx or UPS as a private individual, a departure from the past. And until these policies changed, they were your only options for mailing handguns unless you used an FFL to do so. While there have been some attempts at alternative services to alleviate the issue, it's still a pain in the ass. This bill would repeal the federal ban on pistols, revolvers, and other concealable firearms from being mailed through the United States Postal Service. On top of that, it would prohibit the Postmaster General from making any rules that prohibit or impede the mailing of firearms, ammunition, or components. Lastly, it would prevent the postmaster from implementing a rule that requires the receipt, the firearms transaction record, or other customer records kept by licensees, and the disclosure of any serial number from being a condition to mail the firearm. Hopefully this bill gains some traction so that ordinary people can ship guns they may have sold online to the buyer's FFL without having to incur significant additional expenses due to the current state of affairs. Yeah, I see your 556-inch Pelican case on Facebook Marketplace at $1,200. Real sneaky. In other positive 2A news, Tennessee Governor Lee put his pen to paper last week signing legislation that strengthens the state's PLCA law. In short, that's the law that prevents gun makers from getting sued into oblivion, and that newly signed law goes into effect July 1st. The new law removes the ability to bring a civil liability action for negligence per se. Google it, against a seller of a qualified product while expanding what is encompassed in that category beyond firearms and ammunition to include things like knives, body armor, pepper spray, silencers, and other certain products that are unnamed. The law also makes various other changes regarding civil actions against arms dealers, manufacturers, and sellers, and the preemption of local regulation of firearms. Notably, the law provides for treble damages, that's 3 times the amount, cited by the plaintiffs in their lawsuit if the action is found to be in violation of Tennessee law, along with attorney fees and costs. That provision is a big deal and something lacking in the Federal Protection of Lawful Commerce and Arms Act. Hey Congress, pay attention here. So, why is this a big deal? Lawsuits cost a shitload to defend, particularly ones that are brought as a way to bankrupt an industry through lawfare. Recovery of attorney's fees and costs, along with 3 times the amount of requested relief by the party suing, will go a long way to dissuade bullshit lawsuits. All in all, it's a win for the Second Amendment because if these lawsuits are allowed to continue, eventually it will result in manufacturers closing their doors due to the costs associated with defending against these actions. Some exciting news coming out of California. The state's now accepting applications for non-resident carry permits thanks to a lawsuit brought by the Second Amendment Foundation, CRPA, GOA, and others. In late April, the court's injunction went into effect and allows members of the organizations to apply for non-resident permits. Prior to this win, it was impossible for a non-resident to carry in California because the state did not issue non-resident permits nor recognize the validity of other states' permits. So, if you're planning on spending time in California, check out the website for the sheriff where you'll be headed. Unfortunately, it's not going to be as simple as other states where you just apply, as there's training requirements attached, but hey, at least now there's an avenue to lawfully carry a firearm to defend yourself in the Golden State. Surprising as all that feels, I'll restate it for the record, that's good news for gun rights.